This isn't just a Second Amendment issue, it's not just a firearms issue, it's an issue of an overreaching government that wants to come into your kitchen, that wants to come into your living room and just see what you're doing.
Hi, I'm Tracy Oppenheimer for Reason TV. I'm here with Dimitri Karas. He's the Chief Executive Officer of Aris Armor in Oceanside, California, which recently got raided by the ATF. Dimitri, thank you for talking to us.
Yeah, thanks for having me on.
Give us the play-by-play of the raid. How did they threaten your business?
Well, what happened was last week, they actually approached us through our legal counsel and they requested that we turn over a product that was that they had determined to be a firearm, and they had also requested that we turn over a list of customers to them. The penalty for not doing so, as it was explained to me through our legal counsel, was that they would execute a search warrant against all of our buildings, take all of our files, take everything, and make life very difficult. So we went to the court system and we asked them for a restraining order to be placed against the ATF until this situation could be figured out. We were granted a temporary restraining order. That temporary restraining order was then later clarified to include the language that it did not prohibit them from conducting lawful criminal investigations. The very next day, they executed a search warrant against all of our buildings, and they proved me right. I went to the court system and I said, hey, I'm being threatened, this is wrong, these are not firearms, please, let's handle this the right way in court, and let's work this issue out. And the response was, well, we're just going to come in and actually make good on those threats that we made towards you.
What did they end up taking?
They took our computer systems, they took the product that was in question, a myriad of paperwork and other items here and there.
And talk about the parts in general. They're AR-15 lowers, they're plastic, they're easier to produce, and their problem is that the serial number isn't there. Why do you think that these parts should be freely sold?
What they've said in the past is in regards to the AR-15 80% receivers, which are not firearms, is that it's an object that's in the shape of a receiver, but it hasn't been completed to a point that it would be considered to be a firearm, is that there's 5 operations that need to be left uncompleted that would have to be completed by the consumer in order for it to be sold in that stage. And the only real material difference is the material itself. Instead of being out of metal, it's out of polymer.
Right, and that brings up an interesting point. I mean, it is legal for people to assemble these on their own, and it's also interesting because these parts, I mean, people can print them at home with a 3D printer now. I don't understand why they're targeting your store. This was
a nice way for them to get their arm inside of our business and grab the information that they're actually looking for. To think that this is over, a piece of plastic is ludicrous. It's ludicrous. This situation was already handled in the courts. There was no need for a raid to happen. I had literally had a meeting with 2 of the ATF agents after we'd had the temporary restraining order granted to us. I took them into the building where the polymer lowers were being housed, where we had separated them from the rest of our inventory, and we placed them in a separate room under lock and key. I offered to hand the key to this room, the only keys in existence to this room, to the ATF agents that were there so that they would be 100% assured that we did want this handled in the court system and that we weren't trying to pull anything underhanded and divest ourselves of the product or do anything like that. There was also a camera pointed directly at this door, and I offered the ATF if they would like to have access so they could view this camera remotely. They turned me down on that as well.
Do you feel like that you've been singled out, or this is more of a widespread issue on a war on gun ownership?
I was offered an under-the-table deal. The only reason that this has any attention to it is because I said no. I said, no, I'm not going to give you a customer list. I'm not going to give you this. This is wrong. What you're doing is wrong. Let's handle this in the court system. I can only imagine how many times business owners are approached by the government and these deals are taken and accepted. The only difference in this case is that we said no and we stood up.
And they say, it's for security reasons, but you say, privacy is more important than these alleged security concerns, whether or not they're legitimate.
As our founding fathers have said, giving up liberty in exchange for a false pretense of security, the way that we are founded and how far we've gone from our original intention, it's unbelievable. The fact that they use Gestapo-style tactics against honest, hardworking people, the fact that they invade our lives on every possible level, and they just get away with it. They continue on to do this.
Other than privacy, what other issues are at stake here?
They have trampled on the entire Bill of Rights. And again, the question of privacy versus security, I would make this argument. An armed society is a civil society. So the more armed our society is, the more civil it will be, and that's my opinion again. But this isn't just a Second Amendment issue. It's not just a firearms issue. It's an issue of an overreaching government that wants to come into your kitchen, that wants to come into your living room and just see what you're doing, just poke around in there. And it's none of their business what you're doing.
In California specifically, I mean, we have a lot of excessive gun legislation. Can you talk about what it's like to own a gun shop here?
I get asked a lot of times from other people in the industry, why would you operate inside of the firearms industry in California? That doesn't make any sense. This is my home. I'm not going anywhere. I'm not getting pushed out by somebody who's got an agenda that is contrary to what my rights are. And every time somebody from the firearms community leaves California because of the oppression that's going on here, what you're saying is that, well, we're losing one more vote. We're losing one more vote in that fight every time that happens, and the opposition just gets stronger and stronger and stronger.
Well, thank you again, Dimitri.
Absolutely, thank you.
For Reason TV, I'm Tracy Oppenheimer.
Scott A. McMillan, SBN 212506. The McMillan Law Firm, APC. 4670 Nebo Drive Suite 200. La Mesa, California, 91941-5230. Tel 619-464-1500-X14//fax 206-600-5095. Email, scott@mcmillanlaw.us. Alan Alexander Beck, SBN 276646. Attorney at Law. 4780 Governor Drive. San Diego, California, 92122. Telephone, 619-971-0414. Email, ngord2000@yahoo.com. Attorneys for Dimitrios Karas. United States District Court. Southern District of California. Dimitrios Karas, an individual. Plaintiff. V. William D. Gore, Sheriff, in his official capacity, County of San Diego, a municipal corporation, unknown San Diego County Sheriff's Department Facebook fan page administrators I. through V, in their individual and official capacities, inclusive, does 6 through XX, inclusive. Defendants. Case No. Complaint for damages. Deprivation of civil rights. Declaratory and injunctive relief under the First Amendment to the United States Constitution. 42 U.S.C. 1983, and the Constitution of the State of California. Jury trial demanded. Plaintiff alleges as follows. General allegations. 1. This court has subject matter jurisdiction under 42 U.S.C. 1983 and 28 U.S.C. 1331, 1343, 2201, and 2202. This court has supplemental jurisdiction. 1. 4 CV 2564 Ben KSC. Over state law claims under 28 U.S.C. 1367. 2. Plaintiff is informed and believes, and based thereon alleges, that defendant County of San Diego, sued in its capacity as a municipal corporation, is a municipal corporation incorporated under the laws of the state of California, and a person subject to liability under 42 U.S.C. 1983. 3. Plaintiff is informed and believes, and based thereon alleges that defendant Sheriff William D. Gore, sued in his official capacity is, at all times, relevant herein, an agent acting under color of state law, and a person subject to liability under 42 U.S.C. 1983. 4. Plaintiff is informed and believes, and based thereon alleges that defendants designated as unknown San Diego County Sheriff's Department Facebook fan page administrators I through V, inclusive, sued in their official and individual capacities are, at all time, relevant herein, agents acting under color of state law, and are persons subject to liability under 42 U.S.C. 1983, and are responsible, in some manner, for the events and happening described herein. The true names and capacities of the various unknown San Diego County Sheriff's Department Facebook fan page administrators are not currently known to plaintiff. Plaintiff will amend this complaint to reflect the true names and identities of the aforementioned parties at such time as they become known. 5. Plaintiff is informed and believes, and based thereon alleges, that defendants, and each of them, including unknown San Diego County Sheriff's Department Facebook fan page administrators, sued in both their personal and official capacity, inclusive, were the agents, servants, employees, successors, assignees, transferees, and / or joint venturers of its co-defendants, and each was, as such, acting within the course, scope and authority of said agency, employment, and / or joint venture, and was acting with the consent, permission, and authorization of each of the remaining defendants. Also, defendants, when acting as a principal, may have been negligent in the complaint for damages and injunctive relief to selection and hiring of each and every other defendant as agent, employee, and / or joint venturer. All actions of each defendant as alleged herein were ratified and approved by every other defendant or its officers or managing agents. 6 defendants, does 6 through XX, inclusive, were at all relevant times employees of defendants, and in doing the acts herein described, acted within the course of scope of their employment with defendants. 7. Plaintiff is ignorant of the true names and capacities of defendants sued herein as does 6 through XX, inclusive, and therefore, sues these defendants by such fictitious names. Plaintiff will amend this complaint to allege their true names and capacities when ascertained. 8. This court has personal jurisdiction over defendant County of San Diego because it is a municipal corporation incorporated under the laws of the State of California. 9. This court has personal jurisdiction over defendants Sheriff William D. Gore, in his official capacity, unknown San Diego County Sheriff's Department Facebook fan page administrators, inclusive, in their individual and official capacities, and does 6 through XX, inclusive, because they are agents of a municipal corporation incorporated under the laws of the State of California. 10. This court also has personal jurisdiction over each of the defendants, because plaintiff alleges that they, inter alia, acted under the color of state laws, policies, customs, and / or practices of the County of San Diego, a municipal corporation. 11. Plaintiff Demetrius Carras is an individual, residing in the County of San Diego, California. 12. Venue is proper under 28 U.S.C. 1391. 13. Plaintiff hereby demands a jury trial under Federal RCIP P 38, b. Factual allegations. 14. Defendants operate a Facebook fan page for the San Diego County complaint for damages and injunctive relief. 3. 19. Sheriff's Department, where it invites the internet community to share its opinions on any topic, to post anything they want on their social media accounts via comment postings on its Facebook fan page. San Diego County Sheriff's Department, https://www.facebook.com/sdsheriff, last visited October 10, 2014. Plaintiff attaches a printed image of the general information section of the Facebook fan page hereto as Exhibit 1. Exhibit 1 is specifically incorporated herein as is restated verbatim herein. About Sheriff Bill Gore, Official San Diego County Sheriff's Department. This is a non-emergency communications tool. in an emergency dial. 9-1-1. Description. The San Diego County Sheriff's Department is the chief law enforcement agency in San Diego County. The department is comprised of approximately 4,000 employees, both sworn officers and professional support staff. The department provides general law enforcement, detention, and court services for the people of San Diego County in a service area of approximately 4,200 square miles. In addition, the department provides specialized regional services to the entire county, including the incorporated cities and the unincorporated areas of the county. Sheriff's role. The sheriff, elected by the residents of San Diego County, is the chief executive of the department. He manages 7 major detention facilities as well as 8 major patrol stations, 4 patrol, complaint for damages and injunctive relief 4 substations, a crime laboratory and an array of support operations necessary to provide full law enforcement coverage for the county of San Diego. General service areas. The San Diego County Sheriff's Department is organized into 6 general service areas, which includes the following: Office of the Sheriff, Law Enforcement Services, Detention Facility Services, Court Services, Human Resource Services, Management Services, Law Enforcement Services. The San Diego County Sheriff's Department provides contract law enforcement services for the cities of Del Mar, Encinitas, Imperial Beach, Lemon Grove, Poway, San Marcos, Santee, Solana Beach, and Vista. In these cities, the Sheriff's Department serves as their police department, providing a full range of law enforcement services including patrol, traffic, and investigative services. In the unincorporated, non-city areas, the Sheriff's Department provides generalized patrol and investigative services. The California Highway Patrol has the primary jurisdiction for traffic services in unincorporated areas. Complaint for damages and injunctive relief 5. 8 detention services. The San Diego County Sheriff's Department operates 7 detention facilities. Male arrestees are booked at the San Diego Central Jail and Vista Detention Facility, while female arrestees are booked at the Las Colinas and Vista Detention Facilities. The remaining jails house inmates in the care of the sheriff. In order to provide critical services to a daily inmate population over 5,000, the Detention Services Bureau is supported by a state-of-the-art food services production center, comprehensive medical services, laundry, commissary, and inmate processing services. The Inmate Services Division provides a number of educational and rehabilitative programs aimed at improving the re-entry success of those returning to our communities. Court Services. In January 2000, the former San Diego County Marshal's Office merged with the Sheriff's Department. Since that time, the Sheriff has provided court security and related services for the San Diego Superior Court at several locations throughout the county. General information. We are not opposed to dissenting opinions on topics we post, but we ask that our social conversations remain civil, respectful, and on topic. Many of our postings concern matters of employee and volunteer successes. We believe it is the height of incivility to use complaint for damages and injunctive relief 6. Those opportunities to vent about unrelated topics or offer unrelated insults. We are respectful of the right we all have to free speech. We invite any users with opinions on any topic to post anything they want on their social media accounts. We simply ask for a degree of civility when making comments on our pages. Any user would likely expect the same of those posting made by others to their pages. Comments on topics outside these postings may be directed to the Sheriff's Department via http://www.sdsheriff.net. For information about job opportunities with the Sheriff's Department, visit http://www.joinsdsheriff.net. 15 Plaintiff alleges that defendants have a policy and custom to screen comments after they are posted by individual members of the community, and later manipulates the nature of discussion by deleting those comments that are unfavorable to the defendants, and by keeping comments that are favorable for display to the public. 16 On or about September 2, 2014, plaintiff posted a comment on the San Diego County Sheriff's Department's Sheriff's Department Facebook fan page. 17 Within the hour, defendants removed plaintiff's comment and banned plaintiff from posting on the Sheriff's Department Facebook fan page. 18 On or about September 3, 2014, plaintiff called defendants and asked for clarification on the removal of his comment and subsequent banning of his personal Facebook account. 19 Defendant unknown San Diego County Sheriff's Department Facebook fan page administrator a female, informed plaintiff that she knew who plaintiff was, and that she would not allow plaintiff to post on the Sheriff's Department Facebook fan page. Complaint for damages and injunctive relief 7. 20 On September 3, 2014, under the alias Jim Block, plaintiff posted political commentary in the form of a comment on the Sheriff's Department Facebook fan page under a post entitled #Break4Buses. Plaintiff's comment comprised of the following: Sheriff Gore, do you plead the fifth about your involvement in the murder of an unarmed woman who was holding her baby? Remember Ruby Ridge? Plaintiff attaches a printed image of the comment hereto as Exhibit 2. Exhibit 2 is specifically incorporated herein as is restated verbatim herein. 21 Less than an hour later, on September 3, 2014, defendants censored plaintiff's criticism of defendant Sheriff William D. Gore, by removing plaintiff's comment. Plaintiff attaches a printed image of the Sheriff's Department Facebook fan page that shows government censorship hereto as Exhibit 3. Exhibit 3 is specifically incorporated herein as it is restated verbatim herein. 22 Defendants provided plaintiff no notice or opportunity to be heard. 23 On or about September 4, 2014, plaintiff sent a letter to defendants alleging that defendants have violated the First Amendment by censoring plaintiff's political commentary. Plaintiff attached a printed image of the letter hereto as Exhibit 4. Exhibit 4 is specifically incorporated herein as if it was restated verbatim herein. 24 Despite receiving plaintiff's letter, and being on notice of First Amendment violations, defendants continue to cherry-pick comments on the Sheriff's Department Facebook fan page in order to cultivate a self-serving political image. Defendants continue to punish those that fail to conform to the government message by banning them from further discussion. Complaint for damages and injunctive relief 8. First cause of action. Claim for damages for violation of the First and 14th Amendments to the United States Constitution and 42 U.S.C. 1983. Against all defendants. 31 The First Amendment provides that Congress shall make no law abridging the freedom of speech. U.S. Constant Amend. I. The protections afforded in the First Amendment are within the protective scope of 42 U.S.C. 1983 Cinevision Corp. v. City of Burbank, 745 F.2 D 560, 566, 9th Sir 1984. Therefore, actions by police officers that amount to retaliation against persons for criticizing government officials violates the First Amendment, and creates a cause of action under 42 U.S.C. 1983. See Hale v. Townley, 19F.3d 1068, 1073, 5th. Sir 1994. 32 If a plaintiff seeks injunctive relief, irreparable harm is presumed if he alleges First Amendment violations, even for minimal periods of time. C. Goldie's Bookstore, Inc. v. Super. CT of Cal, 739 F.2d 466, 472, 9th Sir 1984. L. Rod v. Burns, 427 U.S. 347, 373, 1976, holding that the district court abused its discretion in denying a preliminary injunction remedy for plaintiffs who alleged threats to First Amendment interests in their complaint. Plaintiff so alleges here. 33 Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 32, and each and every part thereof with the same force and effect as those set out at length herein. 34 Plaintiff alleges that the defendants get their authority under state law, and act under the color of state law when they act in their capacity as agents of a municipal corporation. 35 Plaintiff alleges that defendants operate the Sheriff's Department Facebook fan page in such a fashion that it indiscriminately invites and encourages Internet users to engage in discussion within its postings. Complaint for damages and injunctive relief 10. 36 Plaintiff alleges that defendants deleted political commentary that was unfavorable to defendants, and forbade plaintiff from participating on the Sheriff's Department Facebook fan page for arbitrary reasons. Such speech is core political speech, a form of expression integral to the system of government. See Buckley v. Valeo, 424 U.S. 1, 39, 1976. 37 Plaintiff alleges that defendants promoted the viewpoint that defendants are immune from public criticism by selectively keeping comments that praise defendants, while eliminating those that cast defendants in an unfavorable light. 38 As a direct and proximate result of defendants' actions as described above, plaintiff has suffered as follows. Plaintiff was compelled to curtail activity and speech protected by the First and 14th Amendment to the United States Constitution. Plaintiff was caused to fear the erosion of his civil liberty and rights, as provided by the United States Constitution. 39 Plaintiff alleges that no reasonable police officer, knowing that the First Amendment right to engage in political discourse in a designated public forum is clearly established, would so wrongly and arbitrarily regulate political discourse in the same manner as defendants. 40 Plaintiff alleges that defendants, even after being placed on notice of First Amendment violations, ratified its previous wrongful behavior, and continues its wrongful custom or practice to censor the public debate. 41 Plaintiff alleges that such brazen censorship is not in the public interest. 42 And that plaintiff is likely to succeed on the merits of the instant case. 43 Plaintiff alleges that defendants' actions violate the First and 14th Amendments to the United States Constitution and that the current cause of action is within this court's jurisdiction under 42 U.S.C. 1983. 44 Plaintiff has suffered damages, and requests compensatory and punitive damages against defendants. 45 Plaintiff also seeks injunctive and declaratory relief against defendants. 4. Complaint for damages and injunctive relief 11. 28. Attorney's fees pursuant to 42 U.S.C. 1988, and for such other reasonable and just relief as the law permits. 46 Defendant's conduct was driven by evil motive or intent, or involved a reckless or callous indifference to the constitutional rights of others. Morgan v. Wosner, 997 F.2d 1244, 1255, 9th Sir 1993. Thus, plaintiff is entitled to an Award of punitive damages in an amount according to proof of trial. Second cause of action. Due process violation. Against all defendants. 47 Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 46, and each and every part thereof with the same force and effect as those set out at length herein. 48 Defendants denied plaintiffs due process rights protected under the 5th and 14th Amendment to the United States Constitution. 49 Plaintiff alleges that defendants deleted plaintiff's comments and banned his further participation of political discussion without any meaningful explanation. 50 Plaintiff alleges that he has no means to appeal the deletion and / or ban or seek relief from a higher authority. 51 Plaintiff alleges that no policies or procedures have been developed or promulgated to help guide defendants' decisions and actions to protect plaintiff's First Amendment interests. 52 Plaintiff seeks injunctive and declaratory relief against defendants, and for such other reasonable and just relief as the law permits. 53 Plaintiff has suffered damages, and requests compensatory and punitive damages. 54 Defendant's conduct was driven by evil motive or intent, or involved a complaint for damages and injunctive relief. 12. Reckless or callous indifference to the constitutional rights of others. Morgan v. Wosner, 997 F.2d 1244, 1255, 9th Sir 1993. Thus, plaintiff is entitled to an award of punitive damages in an amount according to proof of trial. Third cause of action. Claim for damages for violation of the Constitution of the State of California. Against all defendants. 55 Plaintiff incorporates by reference the allegations contained in paragraphs 1 through 53, and each and every part thereof with the same force and effect as those set out at length herein. 56 This court has supplemental jurisdiction over the state law claim, under 28 U.S.C. 1367. 57 Defendants' actions, as described above, violated Article 1, Section 2 of the Constitution of the State of California, and plaintiff is entitled to injunctive and declaratory relief, as well as attorney's fees pursuant to Cal Code of Civ PROC 1021.5. 58 Plaintiff is informed and believes, and based thereon alleges, that his exercise or enjoyment of rights secured by the Constitution or laws of the United States, or of rights secured by the Constitution or laws of the state, have been interfered with defendants, and each of them. Accordingly, plaintiff may institute and prosecute in his own name and on his own behalf a civil action for damages, including, but not limited to, damages under Cal Civ Code 52 and 52.1. Injunctive relief, for attorney's fees pursuant to Cal Civ Code 52.1, H, and other appropriate equitable relief to protect the peaceable exercise or enjoyment of the rights or rights secured, in accordance with Cal Civ Code 52.1. 59 Plaintiff has suffered damages, and requests compensatory and punitive damages. Complaint for damages and injunctive relief. 13. 8. 60 As the conduct set forth is malicious, oppressive, and fraudulent as such term is used in Cal Civ Code 3295, plaintiff is entitled to an award of punitive damages in an amount according to proof at trial. Count 1. Claim for damages for violation of Article 1, Section 2 of the Constitution of the State of California. Against all defendants. 61 Article 1, Section 2, A, of the Constitution of the State of California provides that every person may freely speak, write, and publish his or her sentiments on all subjects, being responsible for the abuse of this right. A law may not restrain or abridge liberty of speech or press. 62 defendants' actions, as described above, violated Article 1, Section 2 of the Constitution of the State of California, and plaintiff is entitled to injunctive and declaratory relief, as well as attorney's fees pursuant to Cal Code of Civ PROC 1021.5. 63 Plaintiff is informed and believes, and based thereon alleges, that his exercise or enjoyment of rights secured by the Constitution or laws of the United States, or of rights secured by the Constitution or laws of the state, have been interfered with defendants, and each of them. Accordingly, plaintiff may institute and prosecute in his own name and on his own behalf a civil action for damages, including, but not limited to, damages under Cal Civ Code 52 and 52.1. Injunctive relief, for attorney's fees pursuant to Cal Civ Code 52.1, h, and other appropriate equitable relief to protect the peaceable exercise or enjoyment of the rights or rights secured, in accordance with Cal Civ Code 52.1. Complaint for damages and injunctive relief 14. 2. 64 Plaintiff has suffered damages, and requests compensatory and punitive damages. 65 As the conduct set forth is malicious, oppressive, and fraudulent as such term is used in Cal Civ Code 3295, plaintiff is entitled to an award of punitive damages in an amount according to proof at trial. Count 2. Claim for damages for violation of the due process clause of the Constitution of the State of California. Against all defendants. 66 Article 1, Section 7 of the Constitution of the State of California provides that a person may not be deprived of life, liberty, or property without due process of law or denied equal protection of the laws. A citizen or class of citizens may not be granted privileges or immunities not granted on the same terms to all citizens. 67 Defendants' actions, as described above, violated Article 1, Section 7 of the Constitution of the State of California, and plaintiff is entitled to injunctive and declaratory relief, as well as attorney's fees pursuant to Cal Code of Civ PROC 1021.5. 68 Plaintiff is informed and believes, and based thereon alleges, that his exercise or enjoyment of rights secured by the Constitution or laws of the United States, or of rights secured by the Constitution or laws of the state, have been interfered with defendants, and each of them. Accordingly, plaintiff may institute and prosecute in his own name and on his own behalf a civil action for damages. Complaint for damages and injunctive relief 15. Including, but not limited to, damages under Cal Civ Code 52 and 52.1. Injunctive relief, for attorney's fees pursuant to Cal Civ Code 52.1, h, and other appropriate equitable relief to protect the peaceable exercise or enjoyment of the rights or rights secured, in accordance with Cal Civ Code 52.1. 69 Plaintiff has suffered damages, and requests compensatory and punitive damages. 70 As the conduct set forth is malicious, oppressive, and fraudulent as such term is used in Cal Civ Code 3295, plaintiff is entitled to an award of punitive damages in an amount according to proof at trial. Prayer for relief. Wherefore, plaintiff prays for judgment as follows. As to the first and second causes of action. 1. Declaratory judgment that defendant's administration of the Sheriff's Department Facebook fan page and the policies governing its use violate the First Amendment of the United States Constitution. 2. Declaratory judgment affirming that defendant's administration of the San Diego County Sheriff's Department Facebook fan page and the policies, customers, and/or practices governing this administration violate the 5th and 14th Amendment of the United States Constitution. 3 for attorney's fees, statutory fees, and costs under 42 U.S.C. 1988. 4 compensatory damages, and 5 punitive damages under 42 U.S.C. 1983 within the meaning of Morgan, 997 F.2d at 1255. As to the third cause of action, 1 declaratory judgment that defendant's administration of the Sheriff's Department Facebook fan page and the policies governing its use violate the California Constitution. Complaint for damages and injunctive relief 16. 2 declaratory judgment that defendant's administration of the Sheriff's Department Facebook fan page and the policies governing its use violate Article 1, Section 2 of the California Constitution. 3 declaratory judgment affirming that defendant's administration of the San Diego County Sheriff's Department Facebook fan page and the policies, customers, and/or practices governing this administration violate Article 1, Section 7 of the California Constitution. 4 for attorney's fees, statutory fees, and costs under Cal Code of Civ. PROC 1021.5. 5 for attorney's fees, statutory fees, and costs under Cal Civ Code 52 and 52.1, including 52.1, h. 6 compensatory damages, and 7 punitive damages for malicious intent and oppressive conduct against plaintiff. As to all causes of action, 1 a temporary retraining order compelling defendants and/or their officers, agents, servants, employees, and all persons in concert or participation with them who receive notice of this injunction, to restore plaintiff's deleted posts, to permit plaintiff to participate in the forum discussions, and restraining defendants and/or their officers, agents, servants, employees, and all persons in concert or participation who receive notice of this injunction but any person for political speech made on the Sheriff's Department Facebook fan page and/or removing protected speech from the Facebook fan page. 2 preliminary and/or permanent injunctive relief compelling defendants and/or their officers, agents, servants, employees, and all persons in concert or participation with them who receive notice of this injunction, to restore plaintiff's deleted posts, to permit plaintiff to complain for damages and injunctive relief 17. Participate in the forum discussions, and restraining defendants and/or their officers, agents, servants, employees, and all persons in concert or participation who receive notice of this injunction but any person for political speech made on the Sheriff's Department Facebook fan page and/or removing protected speech from the Facebook fan page. 3 compensatory and/or punitive damages, and 4 such other and further relief, including injunctive relief, against all defendants, as may be necessary to effectuate the court's judgment, or as the court otherwise deems just and equitable. Respectfully submitted. Dated, October 27, 2014. The Macmillan Law Firm, APC. By _/S/Scott A. Macmillan. Scott A. Macmillan. Attorney for Plaintiff. Demetrius Karras. Demand for jury trial. Plaintiff demands a jury trial on all causes of action so determinable. Dated, October 27, 2014. The Macmillan Law Firm, APC. By _/S/Scott A. Macmillan. Scott A. Macmillan. Attorney for Plaintiff. Demetrius Karras. Complaint for damages and injunctive relief 18.
Hey Charlotte County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago. And so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County Cop Watch with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me, and I'm sick of it. So I'm trying to wake people up. But my wife would love it if some, if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave a, let's say, actually, yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But, do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it, 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt-free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.